All right, students, welcome to this week's lecture for BUL 3130. We're going over civil dispute resolutions this week. This will be a split up week or module. I'll be doing civil dispute resolutions this week. Next week, you'll be getting the next chapter in this module. Splitting it up, it's going to have a case study in it. I give you 2 weeks for the case studies. I'll talk about that. I will probably do an extra video for Canvas that'll cover the case studies and kind of go over those. There are certain things to look at in those. I want to make sure you're getting everything done right and get off on a good foot with those, and then we can build as we go with those. The first thing I want to cover before I get into the material is the quiz and kind of what was going on with that. So for some, it wasn't an issue. Others, the essay questions kind of got you on the score. I don't know if maybe it was a time issue or if it was what it may have been, but the next to the last question was asking about 5 different theories there and comparing what Neil in the question had done with his ethics and comparing it to all 5. Some of you just gave me a simple answer of one sentence. Some gave a couple of sentences, but you need to make sure you're comparing it when you have one where it says to discuss it or compare it or however with all of these, that you're doing that with each one of those pieces. So there was 5 of those in that, and all 5 of those should have been discussed. So that would explain if you missed some points there. If you need clarification on that when you look at your score, just send me a message and I'll go over it with you, and we'll make sure you understand where those points may have disappeared to. All right, so with that said, we're going to get into the material. And this week, like I said, it is dispute resolution. Should be ready to go. All right. So with dispute resolution, this is how we handle things within our system. There are various ways we do this. We'll talk about the court system a little bit. We'll go into different aspects of that. We'll talk about what jurisdiction is. We'll cover a couple of different types of jurisdictional issues, and then we'll go through civil dispute resolution. Now, later in the semester, we'll be covering torts, which happen in our civil courts. And so some of this you'll hear similar to it later in the semester, but this will be kind of a rundown of what the civil procedure is with our court system. And we'll also finish it up with a quick look at ADR, or the alternative dispute resolution options that are out there. Once again, I want to encourage you to always read the chapter. Do not rely solely upon the lectures because there may be things you miss in the lecture that you can pick up in the chapter, or the other way around. These PowerPoints are also available for you to use. They're at the bottom of the modules. If you go all the way down through modules, the PowerPoints are on the very bottom of that. They're most of them, I think all of them, are now named to match the chapter that they're covering or the subject matter that they're covering. Some of them may cover a couple of chapters, but they're set up so that you can look at those, kind of go back and compare as you're doing your notes to get ready for the quiz. A question was asked by one student about how to take notes, because Cengage allows you to take notes as you're reading the book. That may be a good option. It depends on how you're comfortable with it. You may want to take notes in both places, do notes in the book along with notes on paper. However you plan to do that, it's fine. You can use the notes for all the quizzes, all the exams. So however it's easier for you to have access to those when you get ready for those exams. All right, so let's get into the civil system here. So the court system, and our court system is set up similar in our states and our national court system, the federal court system. So there's not a lot of disparity in how they're set up. There are some court specialized courts that work just with inside the federal system. We'll talk about those at a later time. I'll mention those. A couple of those I'll mention throughout the course of what we're doing as we go through different sections. So that's going to be contained in there also. But when we have our laws, we talked last week about law and where law comes from and all the pieces of law. But when we have law, that has to be enforced in some way. And along with that enforcement, there has to be a way for citizens to have their case heard. And we do that within the court system. Our court system is built from the top down as far as our national courts go. Our highest court in the land being the Supreme Court, and then the federal court system under it. We also have the individualized state courts, and there are several other court systems that we'll point out as we go through this lecture. But when we think about it from a business standpoint and what the courts are, companies have to make decisions, right? So they have to make these decisions. They have to, go through things based upon what they are doing, how they're handling situations. And when they do that, they have to do so and take into account what is legal, what kind of litigation they could possibly face because of it. And those type of things, can make it hard for companies to work. So it's important for them to understand what they're doing. So whether it's, their product development that they're doing, whether it's marketing that they're doing, however they're doing it, they have to make sure that they're not infringing upon someone's rights. They're not infringing upon copyrights. They're not, going over into an area where they're not supposed to, and something that could cause them to run into legal trouble. If they're found to have violated the law in some way, a lot of times they face litigation in court. Litigation is our process and our how we go through it. So in a civil case, we have litigants. The litigants in a criminal case are the prosecution and defense. Some of that's very similar in how it's set up. But within our court system, we handle these things, and the process for doing that goes through a lot of times, especially with corporations, they face a lot of federal issues, right? So if a corporation is trying to merge or buy another corporation, which is something we'll talk about extensively toward the end of the course after we get through the midterms, almost before we get to finals. But if they're doing that, if they're working within that system, the Trade Commission looks at it, different agencies look at it, and they decide if that is something that could be done. Is it going to be too big, or there are going to be issues with what they're doing? And normally, if that commission, the FTC or any of those, if they see that it's going to cause a problem where a company could be forming a monopoly, or if not a monopoly, they're getting to the point to where they're cutting out on competition to a certain extent, normally they'll be taken to district court. So the district courts are the trial courts where they have general jurisdiction. They handle cases that are brought there, any federal charges that are filed, things along those lines. They handle any controversies within the federal system. Any question of federal law goes into the federal courts. The question of whether a law is constitutional, whether an act, even to the extent to where we get into the criminal side of things of someone's sentencing. If we have a question of whether or not it's constitutional, a lot of times those will end up in the federal system. There's also some other jurisdictions we'll talk about that will pull a case into the federal system that may not necessarily be a question of the federal, may not be a federal controversy, a legal controversy, so to speak, but it involves citizens of the United States, and it's how they're brought in. Now, when we leave the district court, normally somebody's going to be unhappy with the verdict. We're going to have, one side wins, one side loses, just the way it normally is in court, their next step up is the Court of Appeals. Now you have your district courts that are set up in regions and districts. The Court of Appeals, it funnels to a smaller group, and to that extent. So if you think about what we're looking at here, so if we have this going again, if we look at the court system like a pyramid that works this way, if we think about it in that form, and forgive my artistry here, it's not the best. This would be our Supreme Court, our appellate courts, and our district courts. Now that's not a true to life way they look, but it does funnel down. So if we invert that and you think about it in an inverted way, you have a lot of district courts. So it's like anything else, this part of the triangle is bigger. This begins smaller, so you have less areas to work this. And if it makes it to the Supreme Court, there's only one of those we know in as far as federal systems go. So that's kind of how it breaks down. Now, with that being said, the system works for that reason. The reason that it works that way is because we have a lot more cases that get heard. Not every case gets appealed. Now, a corporation may be happy with what happens as far as businesses go when they go to district court. Whether or not they win or lose the case, they could be happy because it doesn't hurt them too bad. Losing a case, as far as that goes, may not be as devastating in this instance as it would be in a criminal case. All right, so there may just be a fine that has to be paid, or there could be a restructuring. A lot of times corporations, when they decide to merge, one that's been in the works, started a couple of years back, is Kroger and Albertsons, kind of in the Midwest, looking to merge. And they were taking, the commission looked at it and they were taken to court. And the decision was that they had to divest some of their stores. So Albertson had to sell off some stores, Kroger had, so they weren't limiting competition in an area. And a lot of times that's how that works. So they take steps to where they're not limiting that competition. If they're not happy with that, of course, then they can go to those courts of appeals. Right? When we think about why the Court of Appeals and how that is set up, they look at the case. Right, in any instance, as far as an appellate court goes. Now, when we're looking at it in the federal system, there can be federal criminal cases that are brought into the federal system. If the federal government is bringing charges against someone, RICO cases, any type of crime that is considered federal, then if they appeal it, then the court is looking at that appellate court is looking at certain things, but they're not ever looking at guilt and innocence again. All right. So they're looking to see if there was errors made that caused the case to be prejudicial one way or the other to a party. So if it's a defendant that loses, they could base their claim on not being able to present enough evidence. Some of their evidence was excluded, and because of that exclusion of the evidence, it caused the case to be prejudicial against them to the point that it was in error, and it weighed too much on the other side, and there was no way the jury could have came to another verdict. Had they heard the full evidence, been presented with the full evidence, they may have decided different. They can also, file an appeal based upon what the judge's instructions to the jury were. There's several things they could do that. That's just a couple of those that are fairly common. And then whether or not their rights were completely adhered to as they were going through the process. So if the appellate court looks at the case and they decide, okay, there was an error here, they can remand the case back to the trial court and tell them to look it back over, see what's there. They can call for a new trial. They can reverse the verdict or the judgment. They can do whatever it takes to get it sent back. And when they do that, they'll say, okay, first, you need to look at this again and try this with this part intact that may have been excluded, or with different instructions, or whatever it is, whatever the error they saw, they'll tell the lower court, fix the error, redo this, continue with these proceedings, and go from there. If they do not find any error, they'll find for the decision, they'll affirm, it's called affirming that decision that was made by the lower court, and then it'll be up to the party who appealed to decide what they're going to do from that point. The Supreme Court being the highest court, there's always the chance that a case could make it there. So they go through the appeals process, and we see this in a lot of different cases. One party wins an appeal, the next party will appeal that decision. They may win, it may move forward, or someone may lose their appeals, and they keep filing appeals in different courts, different appellate courts, until they can, reach the Supreme Court and hope to get it heard. Now, it's always important to keep in mind the Supreme Court does not have to hear these appeals. They receive thousands of writs of certiorari, which is a writ of cert that they look over and decide if it's something they need to bring into the court. Many of those are denied a hearing. They're denied even being seen. They'll just be sent back. The court will say, well, that's not a question for us to answer. It's already been answered in several different courts or several different cases. But if they do, they'll bring it in and they'll look it over the same way. They do not look at, once again, what was going on. They're looking for errors with something done that caused there to be a prejudicial issue against the party that has filed the appeal. You have some special courts within the federal system also. I alluded to these earlier. The biggest one a lot of people do not realize is bankruptcy. Bankruptcy is its own court within the federal system. You do not have state bankruptcy courts. If a party files for bankruptcy, whether it's a corporation or an individual, they have to do so in the federal court system. And they go before a judge who handles bankruptcy cases. Normally, the attorneys will be steeped in bankruptcy law to help them navigate through the process. They'll have corporate law background, some type of law where they understand this process. Also, if you have to go to court for taxes in the U.S., if it's federal taxes, you go to U.S. tax court. You have, of course, the appeals that go beyond the state level. A case from a state can be appealed in the federal court if there's a federal question involved, or some of the other instances which should cause it to be a federal case. But that's just a quick list of those. That includes some of what is handled in federal courts. A lot of administrative agency issues end up in federal courts also, in an administrative court in front of an administrative law judge. But with these, when they're specialized courts like that, normally the judge that is presiding over that court and over that case will be a judge that only handles that type of case. So we have 56 legal systems in the United States, and I'm not going to try to name all of them, but this is a good way that they break it down. So I'm not going to try to tell you the territorial systems, but we do have the 50 states, the District of Columbia. The federal government has its own court system. The military has their own court system, and then you have the territorial systems. 3 of those that add up to the 56. All those work to make sure that federal law is being handled in the way that it should. Part of what the judicial system does and our court system handles specifically the Supreme Court, but also the lower courts can get into judicial review, is exactly that. It's called judicial review, and it is exactly what it sounds like. All right. So the courts will look at what a branch of government has done or a law that has come about, and they'll review it based upon the Constitution. All right. So does it go against the Constitution? Remember, all laws talked about last week have to be judged against whether or not they're constitutional or not. So the case that spurred this was Marbury v. Madison. All right. Chief Justice Marshall declared it was the Supreme Court's role to decide the meaning of the Constitution. Now, this is, several years after this was going into Jefferson's presidency when this began. So we're at the third president of the nation at that point, and the Supreme Court up to that, kind of the Constitution created them, said they would be there, but there wasn't anything that really stood out as what they were supposed to do. Nobody really pushed it. When this case came about, Chief Justice Marshall and the court declared that this is what the Supreme Court is here. We're here to review decisions made by the executive or legislative branches and make sure that they're doing what they should. And that put the court and the federal system on a level playing ground, an equal playing ground with the other two branches. So anything that they do, if you look at how the checks and balances break down, we understand there's checks and balances that the executive and legislative branch have. The quickest ones to consider, if the legislative branch passes a law, it goes in front of the president can veto that. That's a check on them. They can then turn, if they have enough votes, override that veto and still make it into law. They can, have that check on each other. Now, there's other things that go into it. If the president makes a nomination, it has to be voted in, approved by the legislator. The legislator can't put anything forward without the president's signature. Normally, the president's okay. It's going to be secured prior to that if they're doing what they should do. So they try to get things done, but they're meant to, watch the other party. Now, the courts do not have so many things to do. They do one thing and one thing only, and they're pretty good at it in most cases. And that is they look at what the executive and what the legislative have done, and they question, did they violate the Constitution? Now, they don't do this just on a cursory basis where they're, looking over the shoulder of the two branches. When there's a question raised about something the branches have done, that's when they will then, okay, let's review this and see. The president put out an executive order. We're going to review it and see if that goes against the Constitution. Normally, because someone has filed a suit somewhere in a district court. So somewhere in district court, they filed this suit, and it's made it up to the level where now it's reached the Supreme Court, and the Supreme Court's looking at it, and they make a decision. All right. Now, their decisions can be across the board and sometimes very lengthy. Sometimes they're not. They don't always go along the lines of the party that put that justice in. Recently, we've had conservative justices and liberal justices on the same side of issues, to the point that some things have not passed because two of the conservative justices went along with three liberal justices that are part of the court. Then other times we have stuff that goes right along those lines. And then you do have that rare occurrence where we have a unanimous decision by the court. Because of how polarized the political system is, we don't see that as much as we, it would be nice to see it, but we don't see it quite as much. But we do have, enough things in place that we have, an opportunity for the Constitution to be looked at from different viewpoints and decisions made based upon what they see. how those circuit courts break down. In Florida, we're part of the 11th Circuit. All right, so any federal case that is heard here is done in the 11th Circuit. There are several federal court houses within those. Jacksonville houses one. There are some in other cities in Florida, across Alabama and Georgia. You have some of these that are larger as far as the geographical area, but may not be so much with population. Some of these cover fairly sparse population areas. Others are they carry a real dense population. As far as the number of people that are in there, not the IQ level of the people that are there, but we have a system set up, and you can file and find someone who is in a certain district or circuit to file a case for you. And unfortunately, they shop these courts. You'll see if it's a real conservative issue, normally the parties behind it will try to find somebody in that Fifth Circuit to file the case there, or they'll find a reason to file the case in the Fifth Circuit. Fifth Circuit is notoriously conservative in their decisions. Then we have the Ninth Circuit. Ninth Circuit, not so much. Depending upon where they file it at, normally is based upon what they're trying to accomplish. Now, then it goes to an appellate court, and then an appellate court, and it may end up in the Supreme Court. And currently, the Fifth Circuit is leading the way in being overturned because they are making decisions based upon political ideology more than they are constitutional basis, and a lot of those are getting overturned. And so it may not be the best practice to shop around. You may just need to build a better case. And that really helps. All right, so all that was our federal courts. Now let's look at our state courts. A similar system, we have inferior courts, trial courts, appellate courts, and a Supreme Court in the state of Florida. Your inferior courts are where you would go if you have to appear for a traffic offense. You have some type of issue. A lot of smaller civil cases are handled in those inferior courts also. If it's small, what would be considered small claims court. A lot of what we see on TV and courtrooms, as far as the old days, it was People's Court, Judge Judy. You have all those different TV shows where litigants coming together and a judge sitting up there presiding over their case. That is small claims court. If you'll notice, none of those have attorneys present in most cases. In a small claims court, you do not have an attorney present. For amounts under a certain dollar amount, depending on where you're at. I think it's like $1,500 here in Florida. Last time I looked, it's around $1,500. If you're under that amount, that's considered small claims, and very seldom do you see attorneys present in that. That's those kind of, back and forth between neighbors, a tree falls on a fence or something, those type of things, and they take them to court. They sue them for their placement of the fence or things along those lines. You also have, smaller offenses, minor criminal offenses, will be handled in inferior court. And then you have your trial courts, and your trial courts are going to handle both also. In the state system, you have civil litigation that goes on in trial court, and this is for the bigger cases. All right, so those cases that the bigger law offices like a Morgan and Morgan or a Farrah and Farrah get involved in, those are the ones you're going to see in your trial courts. They're bigger. Criminal cases involving felonies, involving capital offenses, those type of things are going to take place in trial court. That's going to be a different setup. In a inferior court, they may hear a couple different cases a day or so, or maybe more. In trial courts, normally a case is going for an expanded period of time, depending on how much information, how much evidence, a number of witnesses that are brought forward by the attorneys for both sides. So it depends on how that process is going as to how long those will take. Normally, when you get called to jury duty, you're going to a trial court. We wouldn't have normally a jury in inferior court. So when you get that summons to appear for jury duty, you're going to trial court to set either on a civil or a criminal case. We also have some special courts within our states. If you're going through an adoption process, that's done in family court. The complete opposite end of that, when someone is getting divorced, that also happens in family court. Then you have probate. If someone dies without a will or some type of executor to handle their estate, that could end up in probate. That's one of the special courts, and then the special courts handle certain areas of state law, state taxes, things along those lines. Then we have our appellate courts, which are, normally 1 or 2 levels that are in our courts, with the highest court. And in the state of Florida, we have a Supreme Court that is our highest court in the state. That is normally what the highest court is called. The exception that really stands out is the state of New York. If you hear that a case is in the Supreme Court of the state of New York, that's trial court. They have a higher court that is above that, but they consider that Supreme Court in the state of New York. Understanding about the courts brings us to the question of jurisdiction. Now, where is a case going to be heard? Who has jurisdiction over it? What that simply means, jurisdiction is real simple in its meaning. It is the power of or authority of a court to hear and decide a given case. All right. So this is different from venue, which decides a geographical location. This is jurisdiction. Who has jurisdiction over the case? Jurisdiction could be a state matter. It could be a federal matter. It all depends. Your subject matter will sometimes decide jurisdiction also. Once again, we think back to the bankruptcy courts and tax courts. That's subject matter jurisdiction. That'll be handled in bankruptcy court. That'll be handled in a tax court. Right? So we think about what jurisdiction is and how it works. It's based upon, authority and the kind of case. All right? Those are 2 things that it's based on. And I'm going to say it a couple of times because I want you to remember it. Jurisdiction is the authority of a court to hear a case, and it can be based on whether it's federal or state and what the subject matter is. All right, so what can subject matter be? Once again, remember, subject matter, it can be your bankruptcy, it can be your tax courts, in the state systems, that could be family court. It could be, in some cases, you have drug court. There are a lot of jurisdictions now that have drug court that handle specifically those kind of cases and allows for different penalties to be passed down that sometimes will be a rehab or some type of treatment set up. So in federal jurisdiction, we have things that are an exclusive federal question. The exclusive ones are your jurisdiction over any federal crime, bankruptcy, we've talked about, then antitrust. That is when someone is working in such a way that they're hindering competition, they're hindering free entry into a market. They're doing something that causes a hindrance upon trade in a certain market, right? So antitrust. Patent questions, trademark, copyright, and other specified cases. So if someone is questioning a trademark or they're questioning a copyright on an item, that's going to be a federal case. Your federal jurisdiction, which is concurrent, can be both federal and state courts. They have the authority to hear a case. What happens is if there's a federal question, any case that arises under the Constitution, but they do not involve a federal jurisdiction, and if there's diversity of citizenship in the case, which means a party from Florida and a party from Georgia, or the states themselves suing each other. And if it involves more than $75,000 as far as the damages and what's being asked for the damages, that's a concurrent federal jurisdiction. The courts can pull it in. They use things called long arm statutes to bring in certain cases to be heard. State jurisdiction is anything that happens where it's a state case and it doesn't reach the level of federal. There's not that diversity or that $75,000 threshold being met. A diversity of citizenship can be handled in a state court, and normally it's where the injury happened or the harm happened. So that's how that one is taken care of. All right. If the jurisdiction of the parties works in a personam against a person, that's the court's power to adjudicate matters directed at a party. All right. So in a court case, in a criminal case, they would be either the United States government or the government of the state of Florida, or the people of would have jurisdiction over that, depending on where it was at. It can come it comes in two forms of personal jurisdiction, and the other being in rem jurisdiction. And the book goes a little bit further into that. We'll cover it real quick. In rem is jurisdiction based upon claims against property. That's be attachment jurisdiction over defendant's property to obtain payments not related to the property. Someone put up a lien, those type of things. Venue, on the other hand, separate from jurisdiction to a certain extent, is a geographical area. Think of the county you're in. If somebody commits a crime in that county, they're going to face charges in county court in that county. The trial court will most likely happen within that county. The judge that handles those type of cases for your circuit would come around, and they will have the case brought in the local county courthouse. That's the venue. Civil procedure is what all that covers. Now, sometimes we don't need to go, fully into that, and then we have how our disputes are handled. Civil dispute that enters the judicial system, they have to follow the rules of civil procedure. They're designed to help the resolution of the dispute to be just, prompt, and inexpensive as possible. Unfortunately, sometimes they get really expensive. And this part I'm going to go through a little faster because we are getting long on time here. And I want to make sure that I get to the alternative dispute resolutions before we run out of the time I try to allot for these. But basically, when we start a case, we have the pleadings, and I'll make a separate video that'll cover this because we'll talk about these issues again when we come to when we talk about torts. We'll talk about how this goes. When we talk about crimes and criminal law, we'll go over these. But basically, you have to start with the pleadings. In other words, someone has said this has happened to them. They've had a harm committed against them. They file a complaint. Once the complaint is filed, the court will issue a summons to the party who has been accused of this happening, that they've had the lawsuit brought against them. They will be required to file an answer. If they do not file an answer, the court enters into the court that they did not file an answer. In other words, they did not dispute the claim, and they fine for the claimant. At this point, we have not a full defendant yet. We have a complainant and a respondent. The respondent, once they answer, becomes the defendant. They've now defended their actions in some way. They do that by answering line for line each complaint brought against them. So a complaint may not be one simple complaint. There may be a list of things that is put there. Part of a complaint is going to handle names and addresses and phone numbers, those type of things. So they have to answer, is all this true? If they answer yes to everything, we do not have a case. And once again, the court enters into a finding for the complainant. before the plaintiff. They find a finding for them. But at the point they answer no to something, then we end up going through the process, and we'll end up going to court. We have pretrial procedures. This is where motions are filed, trying to get the case dismissed, trying to win the case before it ever goes to trial. Different motions are there to handle that. You can ask for a judgment on pleadings, ask the judge basically to look at what's been brought forward at this point and make a decision. Then we go into discovery, where the parties have to exchange evidence. Once they've done that, we have pretrial conference. Once again, the attorneys are probably going to ask the judge at some point here, they're going to file some type of motion to get evidence excluded. They're going to file a motion to have witnesses excluded. They may try to get the case finalized again, and they may ask for a summary judgment where they're saying, okay, Your Honor, look at this case. There's overwhelming evidence that this has happened. To save the taxpayers' money, let's go ahead and, enter a summary judgment. Once all that happens, if we haven't had any judgments, there's hadn't been any reason for the case to stop, we go into trial. We have voir dire, which is jury selection. Then we have what goes on in the trial. You're going to have opening statements by the attorneys. They're going to examine and cross-examine witnesses. It's called direct and cross-examine. And then they'll have their closing arguments. And later on, I'll get into more detail about what that is. With a directed verdict, we're asking the judge to enter a final in favor of one party based on the evidence that was introduced. In other words, don't go to jury. If that doesn't happen, the judge will give instructions to the jury. This is where you run into those constitutional issues sometimes, and this is where appeals happen, is based upon these instructions. Once the jury goes through it, we know this part. They go to a verdict, guilt or innocence, or liable or not liable. And then motions can happen that challenge the verdict. Then we get to that appellate court. And if there's an appeal filed, it goes to the appellate system. And there are ways to have a judgment that is brought against someone enforced through several different ways, whether it's through a levy on their wages or garnishment, or having local law enforcement seize property based on a court order, taking them to court further to try to get payment out of it, whatever it may be. Now, there's a process to keep from bogging down the court system. That process is called alternative dispute resolution. Now, I'm going to go through these kind of backwards in the slides because I want you to kind of see this. So this slide starts at the lowest and works its way up. The most simple way that a dispute can be handled is negotiation. That's where the parties just come together and they discuss it. You have party A, party B, they come together, they discuss the issue, and they try to negotiate out a agreement that fits the parties. There's not a third party brought in. There's no one there to go in between with between the parties. They're handling this themselves. Then we get to mediation or conciliation. There's two different things here that are real similar. Mediation is non-binding. A mediator is brought in. This is someone paid by the court who comes in, eventually paid by the parties, but the court brings them in. They're on a list, and they sit down and they act as a facilitator or an intermediary between the parties. And they do not make any decision. Nothing they do is binding in the court. They just try to get the parties to an agreement by, making sure that they're negotiating in a fair way and a good conscience, and doing what they should do. Conciliation is very similar. The difference being what the solutions may be. They do not propose the solution so much. They're just trying to get the parties to work. Then we have what is binding. And the binding part is arbitration. Arbitration can be a binding agreement, is a binding agreement that the arbiter will bring forward. Now, arbiter is different than a mediator. A mediator can be anybody. You just have to, go through the process of being trained as a mediator and put on the court role as one. To handle arbitration, you have to go through the process of being an arbiter. Arbiters normally are someone who is a subject matter expert. These are retired judges, lawyers that handle arbitration, that build their practice around arbitration and those type of things. They issue a binding decision based upon what the parties tell them, and while they're hearing from the parties, they will issue a arbitration ruling, and that will go to the judge. Judge will look it over and then enter it into the court as the official ruling. Right. There are some other little pieces that go into that, but for the most part, when we think about what we have here, if it's a decision that comes from adjudication in the court system or arbitration, it's going to be binding. Arbitration is not public. That is still a private matter between the parties with a officer of the court there to handle it. There's going to be some special expertise involved in this. It is paid for with arbitration and mediation. It is ultimately paid for by the parties. They have to put the money out to have this done. There's not really precedent that goes in arbitration. The person who's a subject matter expert may consider that, but it's not, quite as cumbersome as it is in the legal system in our courtrooms. It's not very time consuming to handle, to go through ADR. There's not a lot of long delays because that one person is working specifically with those parties. And it's not near as expensive as it is to go to court. You don't have court fees, you just have whatever it costs to pay the arbiter. And normally if you have attorneys present, or attorneys looking over your cases, you'll pay them. If you go to court, you're going to be paying that attorney from the time you put them on retainer to everything they do they're billing you for all those hours. Plus, you're going to have to be paying some court expenses. And if you lose, you're going to be paying out, whatever it may be. So it gets very expensive that way. All right. So that is going to wind that up. And